There's a couple big ones. So the first one, as you know, the Supreme Court of Canada often does not weigh in on family law matters, but they actually are these days. Last year, there was the big child support case called Michelle and Graydon, and I spoke about that last year. And that was about retroactive child support. And it had an amazing concurring reasons for judgment by Madam Justice Sheila Martin. And if you don't know her, she's out of the Alberta courts, but she's also actually been counsel for Women's Legal Education Action Fund, LEAF, on a number of their cases. So she is very strongly a feminist, and you can hear that in what she says. She talks very much about, the best child support. You have to infuse child support with the best interests of children. So it's a really good read. There's a companion case that sort of came out this year in January, and that's Colucci and Colucci. And it deals with the issue of retroactively reducing child support and rescinding arrears. So this is a case out of the Ontario courts. The parties were divorced in 1996. And just so you know, so when the child support order was made, it was pre-federal child support guidelines. Not a huge deal for this case, but just there are those days where things are pre-child support guidelines. Anyway, in the order, the mother was granted sole custody of the two daughters, and the father was required to pay child support in the sum of $115 per week. 2 years later, the father requested to reduce his child support, but he didn't provide any financial disclosure, so the parties never reached an agreement. From then on, he made no voluntary child support payments, and he was fortunate, of course, that his daughters aged out in 2012, so his child support obligation came to an end. But then, probably because they're equivalent of the Family Maintenance Enforcement Program, Chloe called them and says, hi, you've got $170,000 of arrears going, so we want that. So in 2016, he brought an application to retroactively reduce his child support and then rescind his arrears. So the Ontario court judge, the motions judge, said, you bet, let's reduce your child support arrears by $41,642. Now, this is based on the retroactive being like looking at his income over the number of years. I can't remember how far back he was seeking to go. But so at that point, essentially the trial level judge agreed that the arrears should be, the amount should be reduced. So that takes $41,000 off his $170,000. The Court of Appeal said nope, and ordered the father to pay the full amount of the arrears. So then steps in the Supreme Court of Canada. And cut to the chase, they dismissed the father's appeal and basically put it back to him having to pay the full $170,000. Now, there's a lot of slides that will follow this because the analysis or the discussion from the Supreme Court of Canada is really important. So I really, if you are dealing with child support cases, certainly look at Michelle and Graydon for if your client is trying to get retroactive child support. And look at this case, Colucci, if your client is either trying to retroactively reduce child support, or if your client is trying to defend against an application to reduce child support. Because there's some really important analysis and discussions here. It's like they finally, the big case used to be DBS, but DBS was a particular set of cases that, anyway, there's so much more analysis and discussion here. It's great, finally. So the Supreme Court of Canada held that courts need a wide discretion to vary child support orders to ensure that the correct amount of child support is being paid and to adapt to the enormous diversity of individual circumstances that families face. So there are three interests that have to be balanced in order to achieve a fair result. Number one, and actually this is always a primary factor, the child's interest in receiving the appropriate amount of support to which they're entitled, because as we all know, child support is the right of the child. Two, the interest of the parties and the child to have certainty and predictability. Now, this is both for the payer and for the recipient, right? It's not just the payer having certainty or predictability, but also the recipient needs to know how much am I going to get each month so I can plan my life. And also when you get to it, it's like, if there's a retroactive order and I have to pay back $50,000, holy crap, right? First swear word, I guess. The need for flexibility to ensure a just result in light of fluctuations in the payer's income. So the child's interest in fair standard of support commensurate with income is the core interest to which all rules and principles must yield. Child's interest. So the court said, okay, here's our framework if we're going to decrease child support. First of all, you have to, what's the biggest thing that comes up in child support or spousal support claims? Financial disclosure, right? So the first thing the court says is, look, you need to acknowledge there's what they call an informational asymmetry between the parties. That is, the payer knows what their income is, the recipient doesn't, right? So disclosure is a linchpin on which fair support depends, and the relevant legal tests must encourage timely provision of necessary information. We all know the thing, failure to disclose. Anyway, is the thing that drives the courts over the edge. So if a payer is the one who knows and controls the information, that is the person who has to provide the information. Full and frank disclosure of income. We know from the Family Law Act, Section 5 requires full and frank disclosure, right? So it's built in all throughout. So without full and frank disclosure of income, parties cannot stand on an equal footing required to make informed decisions and resolve child support disputes outside of court. So you can't have an appropriate agreement if you don't have full financial disclosure. And when you get into the court, it's very difficult for the court then to make decisions without full and frank disclosure. They go on and on about these principles, the duty to disclose. It's just tied into the legal obligation to pay support, right? Proactive disclosure on changes to income is the first step in ensuring that child support obligations are, what the heck is that word? Skip. Sorry. I knew there's things. Anyway, so, and then here's like, okay, so how does it work? Now you've got full disclosure. So once you've established there's a material change, and that can be the incomes has changed. And we're not talking about a couple $100s, a couple thousand. It's usually quite significant changes. Then there's a presumption in favor of retroactively decreasing child support. Now you're like, oh my God, it's going to go back 20 years, because now he's given me all his tax returns for the last, since 2000 and he didn't make that money. Don't worry. Well, worry a bit. But there is what we call the presumptive date of notice, like the date in which the court will go back to for retroactive support. There are many cases that I've read in BC, and I've even tried it, where a party is trying to actually get retroactive all the way back as far as they can go. And this Court of Appeal, Supreme Court decision sort of puts a halt on that, right? That the courts aren't just going to say, okay, well, you haven't disclosed for the past, 10 years. Fine, we'll just adjust everything. The Supreme Court says, no. Basically, the date at which we go back to for the retroactive review is when the payer gives effective notice. And it's also only up to 3 years before formal notice of the application to vary. So really 3 years is your marker. So what is effective notice? That's when the payer gives clear communication of the change of their circumstances, accompanied by, this is key, a disclosure of any available documentation to substantiate the change. So it's not enough for the payer to just say, hey, I just lost my job, so I'm not going to pay any child support. Can you sign on the dotted line so FMAP will get off my case? No, you need to have proper documentation. That could be, why the person lost their job, what are they doing to look for new jobs, etc. Right? So it's not enough, as they say, for the payer just to merely broach the subject with the recipient. There has to be more than that. There has to be docs. So in the absence of effective notice, then certainty and predictability for the child are to be prioritized over the payer's interest in flexibility. So if there's no effective notice, you don't go back and give the payer an out, because then that may mean that there's going to be a reduction of child support to make up for overpayments, for example. And that will put the child and the recipient in a very precarious situation. As the Supreme Court says, the recipient is entitled to rely on the court order agreement in the absence of proper communication and disclosure by the payer, showing a decrease in income that is lasting and genuine. Lasting is, it's not just some people say, the courts here had a process for emergency cases because of COVID, if people lost their jobs, but it wasn't meant to be long lasting, that was it. The expectation was when the COVID situations sort of normalized a bit, or people could go back to work, people would have to start paying their support again. It wasn't meant to be a permanent change in the support payable by the payor. And also genuine. Again, somebody quits their job and says, oh, my income went down. I just didn't feel like working here. I'm going to instead, open a ice cream stand, at the beach, and my income will go down a lot. That's probably not very genuine in terms of how the court would see the reason for the decrease in the income. Because the payer has control over the date of notice and the date of retroactivity, because the payer is the only one who knows when their income decreases. So, as I said earlier, even if the payer gives effective notice, you're still only going back to 3 years from the date of formal notice. I'll get to the exceptions to that. And the reason why there's this, what they call the presumptive 3-year limit, is because it allows parties to negotiate, but recognizes that the payer must commence proceedings in a timely manner to protect the certainty interests of the child and the recipient. The court does have discretion to depart from the presumptive date of retroactivity, where the result would be otherwise unfair in the circumstances. You have to compare this also to when a recipient is seeking to increase or is seeking retroactive child support. Although there's this whole notional is only 3 years back, the courts will also go back further more readily than they will in this case, because the recipient generally doesn't have the income information for the payor. So won't necessarily know that they could go back. If they find out, wow, 5 years ago you got this brand new job and you make now $100,000. I didn't know that. So the courts are, in those cases, give more leeway to going back further than 3 years. In this case, it's the payer who has all the information. So they should be able to know, them being able to figure out the 3-year clock is a lot easier. So that's why the presumption of the 3-year limit is more stringently adhered to than on the other side of seeking retroactive child support. So there are 4 factors that were in DBS, and they have been adapted to suit the retroactive decrease context. So one, they look at the payer. Does the payer have an understandable reason for the delay in giving effective notice or formal notice? And this is an important one. The recipient's delay in enforcing arrears is irrelevant. So the payer can't say, well, she didn't ask me for it, or she didn't come chase me. She didn't go to court and, make me pay more. Too bad, irrelevant. The payer's conduct, which includes efforts to disclose and communicate with the recipient and to make genuine efforts to continue paying as much as the payer can. So if a payer just decides, oh, my income went down, I'm just going to pay $0. And they could have paid $200 or $300 versus $600. The court won't look kindly on that. That's one of the factors that will go against the payer in terms of the payer's conduct. Third is the circumstances of a child. So for example, if the child's experienced hardship or is it currently in need? If that is the case, that factor militates towards a shorter period of retroactivity, not back 3 years, maybe we'll give you a year. And here's a big one, as we talked about, the circumstance of whether or not a recipient would be required to repay support to remedy any overpayment. It's rarely appropriate to do a retroactive decrease in support to the date before the recipient could have expected that the support payments might be repaid, because it puts the recipient in a place where, they must find on living with what they had, budgeting accordingly. And usually with child support, it's not like you get to bank a whole bunch of it. You spend it on your kids, that they would have to pay any of it back. And so that's why the courts will be more stringent in sort of like how far back we'll go will also depend on what's that impact going to be on the recipient if there's any overpayments. And the reality is payers only often go back to do retroactive decreases because they say there's an overpayment and they want money back. And hardship for the payer, if the period of retroactivity is not lengthened beyond the 3 years. And this is, again, an evidentiary issue where the payer has to establish real facts supporting a finding of hardship. And where the payor has basically done it to themselves by failing to disclose, for example, or give notice to the recipient, the courts are less inclined to grant an extension of the retroactivity period based on hardship. And finally, the Supreme Court of Canada talks about rescinding the arrears, which was something that the father in this case of Colucci was also seeking. And the court says, be very clear, it has to be based on not only a current inability to pay. It has to be based on the current inability to pay. And that's the only relevant factor. Based on the current inability, is the only relevant factor is the payer's ongoing financial capacity. So it's not just right now, if the payer can pay, but also looking into the future, whether the payer could pay. And so again, onus is on the payer to show sufficient reliable evidence to allow the court to assess what their current and prospective financial circumstances. So the payer will have to do a lot of work. It's not as simple as, hey, look at how bad my income was, the last few years. Give me a break, right? Okay, so there is a presumption against rescinding any part of the arrears. And generally, when there are arrears, it's because there's a court order or an agreement, right? And parties are expected to comply with that, and recipients are generally relying on it. And so the presumption can only be overcome if the payer can establish on the balance of probability that, this is key, even with a flexible payment plan, the payer cannot and will never be able to pay the arrears. So it's not just, as I said, now I can't pay the arrears, or maybe in 2 years I can't pay the arrears. It's like, well, you have to show that you will never be able to pay the arrears. And so they'll keep the arrears alive. If in the event you win the lottery, for example, you get an inheritance, you get a good job, right? So rescission arrears is a last resort in exceptional cases. So what happened in Colucci? Well, I already told you. Do you remember? It was about 15 slides ago. Anyway, the Supreme Court held that the father's deficient communication, his inadequate evidence, and insufficient disclosure were fatal to his application for a reduction of the child support retroactively, and also to his application to rescind arrears. They noted that his conduct shows bad faith efforts to evade the enforcement of court orders. You remember, he didn't pay anything from 1998. Boo.